Okay, folks, Chapter 1 introduces us to evidence. I'm going to skip over the feature case because we're going to discuss this in class. So, what law do we apply and how do we decide when the law applies? So let's look at two cases that deal with war crimes. So in 1945, many Nazis were convicted by Allied war crime tribunals of offenses that were legal under German law. In 2006, Saddam Hussein was convicted for crimes he committed in 1982 against his own people, acts that probably would have been considered legal under his own regime. So just something to think about, when do we apply the law and how do we decide what laws are applicable? So let's start with the concept of evidence. Evidence is some fact that tends to prove or disprove the existence of an alleged fact. So in court, evidence could be testimonial evidence. So this usually comes from witnesses who are sworn in under oath and testify to something they've observed with their five senses. It includes documents that could be written documents, printed documents, electronic documents, and tangible items, actual things we can touch, physical items. In Mapp v. Ohio, we established a legal precedent that in order for evidence to be admissible, it has to have been obtained legally. So in the Mapp v. Ohio case, the police are looking for a suspect, and they force their way into the house of a woman named Dolly Mapp, and they don't have a warrant. What they do, though, is they pretend they have a warrant, and so they show her this fake piece of paper, which she took, and I believe, if I remember correctly, she stuck it in her shirt, and they took it back from her when she tried to take it away. During the search, the police didn't find the suspect, but they did find pornographic material that Mapp was in possession of. So she was arrested and convicted of possession of pornography. This case went to the Supreme Court, though, and the Supreme Court overturned her conviction and said that the admission of this type of evidence is illegal and it's no longer allowed. So evidence obtained illegally is inadmissible in court. So Mapp v. Ohio keeps out evidence that is true evidence. So again, this was evidence that did prove that she was in possession of pornography, which was a crime, in order to protect someone's constitutional rights. So a couple of things to think about. If a fact or evidence exists, is it fair or rational to ignore it in determining the truth? Is this the best application of the right? What alternatives exist, and are they better or worse? So a trial starts with a presumption of innocence, and the burden of proof rests with the prosecution. And so the prosecution has to come up with, the burden of proof basically refers to how much and what the quality of the evidence is that's necessary to establish each element of the crime. And in a criminal trial, that burden is beyond a reasonable doubt. And the prosecution has to meet this burden. So they have to convince the trier of fact, whether that's a judge or a jury, that the defendant is guilty. Defendants are presumed innocent, and they have a burden of persuasion. They basically have to convince the jury or the judge that the prosecutor hasn't proved his or her case. They're not required to prove their innocence. The standard beyond a reasonable doubt doesn't mean proof beyond any doubt. Generally, it means doubt based in reason and common sense. So let's look at the role of the judge and the jury. In a case where there is both a judge and a jury, the judge acts as the trier of law, and the jury acts as the trier of fact. So the judge determines what the law is on any given point, and determines what's admissible, when attorneys object, whether or not, how to rule on that objection. The jury is the trier of fact, so they determine if evidence is to be believed and what weight to give to a variety of different pieces of evidence that are presented. Now, in a case where it's just a bench trial, just a judge, then the judge serves as both the trier of fact and the trier of law. So as I mentioned, the judge controls what evidence is admitted into court or admitted into the trial. There is a presumption that evidence is admitted unless someone objects to it. So the judge basically is going to use their discretion to determine competency, relevancy, and materiality of the evidence. And they're also going to look at whether or not the evidence is too prejudicial. So basically, is it more harmful than helpful? So in Apprendi v. New Jersey, the Supreme Court limited judges' power to include any fact in sentencing. Okay, so this is a case that's looking at sentencing and what facts can be used against you there. And the court held that only facts shown beyond a reasonable doubt can be used to determine a sentence. So in this case, the judge had used information that wasn't proved beyond a reasonable doubt to expand the offender's sentence by 2 additional years. So Apprendi may have committed the crime because of a racial bias, but because it wasn't shown that beyond a reasonable doubt, it can't be used in sentencing. So anything that's used to lengthen your sentence has to be shown beyond a reasonable doubt. Has to be proven beyond a reasonable doubt. So the prosecution generally initiates the criminal proceedings, and at the federal level, that's the U.S. attorney, and at the state level, that's district attorneys. The prosecution represents the state or the government at trial and handles all appeals of those verdicts. Before the trial, a couple of things to think about. What about the ethics of the prosecution? So they should only seek an arrest or seek a search warrant when they have probable cause. They should disclose all useful evidence to the defense. They should prevent undue publicity and ensure constitutional safeguards are followed. The prosecution also assists the police, right? They want to make sure that warrants are issued properly and used properly. They want to help the police determine if any act committed is or is not a crime. And they also help train the police in matters of law. So for minor cases like a traffic ticket, we're generally only going to read a police report before we go to trial. But for major cases, we need to interview witnesses, review evidence, determine how likely a conviction is, look at the level, number, and types of charges, and determine if a plea bargain is appropriate. The defense carries, as I mentioned earlier, a burden of persuasion. So they are not required to prove their innocence, but they generally want to show the prosecution has failed to prove guilt beyond a reasonable doubt. Now, one thing you can do as a defendant is you can raise what's called an affirmative defense. This is where you argue that you did commit the offense or the incident in question, but there's reasons why that wouldn't be legal, why it's not illegal for you to do so. So this includes things like self-defense, duress, intoxication, entrapment, or insanity. And you probably remember these from criminal law. The burden here, though, when you raise an affirmative defense, falls to you, the defendant. You have to prove that. You can also attack the constitutionality of how evidence was obtained. So we do have a right to counsel, which is guaranteed under the Sixth Amendment. And if it is denied, any conviction should automatically be reversed. Defense attorneys are required to be reasonably competent. And if you are too poor to afford an attorney, the state must pay for one. This comes from a case, Gideon v. Wainwright, from 1963. Mr. Gideon was charged and convicted of stealing from a coin-operated cigarette machine. So most of you guys have probably never seen one of these, but just like you have a vending machine for soda, there were vending machines for cigarettes. At trial, he asked for counsel, but was denied, and at the time, counsel was only afforded to you in a capital case if you could not afford one. So he was convicted and sent to prison, and he handwrote his own request for a new trial. On appeal, the Supreme Court said counsel for any indigent offendant is required if they are facing prison time. And this is based on the Sixth Amendment. So let's look at this. Let's think about public defenders. So public defenders have to be, quote, reasonably competent. But how good is good enough? Private defense counsel probably handles a dozen serious cases at a time, whereas a public defender could have 60 or 100 felony cases. And recently, some states have cut back severely on funding of public defenders. So in almost all trials now end in a plea. Is this really considered just? The defense attorney's duties. One of the things that the defense attorney is supposed to do is ensure that due process occurs. So you guys might remember the Fifth Amendment talks about our due process rights. Okay, due process of law. That means that not only are there laws that we need to obey because if we break them, it's a crime, but also there are rules that have to be followed in order to convict somebody of a crime. They're supposed to protect the defendant from an illegal search or a confession. Their job is also to cross-examine hostile witnesses. Ethically, they should not engage in or promote fraud, file or seek frivolous claims, or present false evidence in court. So the rules of evidence. Historically, trials were often unfair. So the Star Chamber and Inquisition starts with presumption of guilt. Jurors often had to have a personal knowledge of a case, and few rules existed to keep bad evidence out. Today, we have uniform rules of evidence that have been proposed and developed, but even with that, different states have different rules. So where does our evidence law come from? Well, part of it comes from the Constitution, and in particular, the Bill of Rights. And it comes from the Constitution and the Bill of Rights as that's been interpreted over time by the courts. So remember, we've talked about 3 court cases in this chapter: Mapp v. Ohio, Apprendi v. New Jersey, and Gideon v. Wainwright, all cases where the Supreme Court made a ruling or a decision as to how to interpret the Constitution and the Bill of Rights. That hits our second bullet point, the U.S. Supreme Court. The Supreme Court defines what the Constitution means and oversees the federal court system. At the federal level, we have federal rules of evidence. These were adopted by the Supreme Court in 1975, and many states have adopted similar models. State Supreme Courts interpret their own state constitutions in much the same manner that the federal court interprets the federal Constitution. There are also state rules of evidence. And then we have case law. Case law is when the courts have to explain or interpret what the law is. So sometimes we have conflicting laws or cases, and sometimes they conflict with whatever the legislature might have actually intended for, when they were passing a particular law. So the rules of evidence evolve with society and technology, and we see this in Supreme Court cases. So in 1967, we have a case, Katz v. U.S., where the Supreme Court developed rules about the expectations of privacy. It's not until 2012, though, where we see the court apply those rules to GPS devices. So technology changes so quickly that we often have to wait for the courts to determine how that law might apply to new and developing technology. Well, where can we do our legal research? We have comprehensive legal sources like an encyclopedia or Wikipedia. Please don't ever use Wikipedia. American jurisprudence, corpus juris secundum. We can read books, newspapers, digests, and annotated codes. We can also look at court opinions, and these are found in a lot of different locations. We do have access to court opinions, and you'll need to access them for two case briefs that you're going to write this semester. One of the things that's helpful with that is looking at how a case is cited in order to find that case. So Miranda v. Arizona, 384 U.S. 436, 1966. So Miranda is the appellant, and they lost the case at trial and they appealed it. Arizona is the appealee, the person who convicted Miranda. The case is found in volume 384 of the U.S. Supreme Court reports, starting on page 436. And 1966 refers to the year in which the case was decided. And that wraps up chapter 1.